about this free and open Indo-Pacific, which is promoted by the Ministry of Foreign Affairs of Japan and Japan as a whole nation, is a vision to develop a free and open Indo-Pacific region as international public goods through ensuring the rule-based international order, attaching importance to ASEAN's centrality and unity in order to bring stability and prosperity for every country, as well as secure peace and prosperity in the region as a whole. So as a general context, Japan is promoting this policy in order to improve and further enhance the relationship of countries in the ASEAN community. But before or upon discussing this issue, we do need to consider its historical background or what has been raised as an issue in terms of this field. So this leads into my main topic for today, historic waters. Have you guys heard of this term before? So this is a pretty vague term. So when you hear this term, you might already have different ideas about that comes into your mind, maybe from the news or books that you've read or seen before. So historic waters itself is an international term alone. So today our focus will be on the topic of the South China Sea arbitration, or more familiarly known as the South China Sea case. To give a brief introduction to this case, the South China Sea arbitration was an arbitration case that was brought by the Philippines against China under Annex 7 of the United Nations Conventions of the Law of the Sea, or which some of you might know as UNCLOS. It's a type of law concerning the sea, international seas. And it concerns certain issues in the South China Sea. So the arbitration concerned the role of historic rights and the source of maritime entitlements in the South China Sea, the status of certain maritime features in the South China Sea, as well as the lawfulness of certain actions by China in the South China Sea that the Philippines alleged to be in violation of the convention. So here I put a visual image here for you guys to visualize and understand this case more fully. But to best understand the situation in the South China Sea from a legal point of view, it is imperative to refer back to the judgment passed by the arbitral tribunal of the Permanent Court of Arbitration, which is this case, in response to the claims brought by the Philippines against China. And as to give a brief background, China has always argued for historic rights in the South China Sea. And as you can see, the red dotted lines there, it says it's labeled as China's 9-9 claim, but China has demanded the 9- line on its official maps of the region in question. So basically, China has stated that the sea or the area of this part of the sea is all China's sea. So while it was the Philippines which brought the case, it wasn't the only interested country, partly in the ASEAN. So 3 other members, including Brunei, Malaysia, Vietnam, also Indonesia, has continuing run-ins with China's fishing vessels and also occasionally with the Chinese coast guards in these areas of the sea, which is in its exclusive economic zone, or the EEZ. So it becomes even more important to look at the arbitral ruling from an objective perspective, so from the legal perspective. So to keep things really simple and short, the Philippines' claims, as stated in the top section there, was mainly concerning disputes that were ongoing at the time. And Philippines did gain a legal victory, which was something that the arbitration issued an unanimous award largely favorable to the Philippines. However, what we need, like in terms of this decision or this case, we do need to consider that China's certain arguments against the jurisdiction were still worthy of discussion. So the tribunal proceeding with the submissions made by the Philippines also considered the validity of China's claim to historic rights in the maritime region of the South China Sea and the Nine-Dash Line, which I mentioned earlier. So I do have a rather long explanation of the Nine-Dash Line in the slide, but so in 2020, China staked claim to 90% of the South China Sea, and this claim is based on the U-shaped Nine-Dash Line etched on the map in the 1940s by a Chinese geographer. So as I mentioned, it is the area there, circled in red. So this is where we come back to the concept of historic waters, which I introduced in the first part. So such terms are not mentioned in the United Nations Conventions on the Law of the Sea, or the UNCLOS, yet quite a few states, including Japan, has claimed historic waters. So historic waters, as a definition itself, refers to waters over which the coastal state, contrary to the general applicable rules of international law, clearly, effectively, continuously, and over a substantial period of time exercises sovereign rights with the acquiescence of the community of states. So this was from the regime of base in international law ratified in 1964. So historic waters are recognized in international law as a legitimate exception to the rules applicable to territorial sea-based lines. But to keep this more simply, and there are the conditions for historical waters would be the conditions. There are three main conditions for a sea-based, the sea area to be considered as a historical water. And one would be a formal claim by the country claiming that area. The second would be effective and continued exercise of the relevant jurisdiction. And the third one would be international acquiescence. So other countries would have to admit that. So in order for a state to benefit from this regime, it would have to comply with these traditional requirements. So going back to the South China Sea case, so for long, China has argued that its claim over the South China Sea is historical in nature, and it was first discovered by China's Han Dynasty more than 2 millennia ago, which is a really, really long time ago. But it does say that these scholars have further argued that a Chinese mission in the 3rd century made accounts of the paracels and spratletes. Then between the 10th and 14th century, during the period of Song and Yuan dynasties, many official and unofficial Chinese accounts show that the South China Sea to be within China's national boundaries. So, however, this historical rights arguments have been challenged on several fronts. So there are various implications of the Nine-Dash Line, and I think all of you can kind of imagine what kind of counter-arguments there would be. But analysts or people say that this the sovereign rights of China is discontinuous, meaning that other countries can pass through. Sorry, not the sovereign rights. The sea itself is discontinuous, so other countries can pass through the lines freely. Other researchers would say that the Nine-Dash Line itself is a maximalist claim to sovereignty and control over all of the features, including land, water, seabed within the area bounded by the Nine-Dash Line. And so that's what the other countries do not wish to happen. So the arbitration itself, the tribunal on its end had taken cognizance of the various factors and purported not to deal with this delimiting maritime boundaries. So I did put in which law, or like which part of the convention was used in this case, but the tribunal did not deal with this issue specifically. Okay, this is just for reference. But as you can see, what I wanted to say here is that this case itself, the whole course of the events, this South China Sea case, is really complicated and a complex issue. And it's something that, as you can see, it lasted for as long as 70 years, and it is still disputed today. And people have varying opinions towards this issue, which does show that these, not just the sea itself, but the relations within the ASEAN countries, within the Asian countries, is really complicated and is not an easy issue to solve. So this case has inspired numerous discussions on legal issues and has been considered as providing a legal background from the maritime activities taken by various countries in the South China Sea. So what are the takeaways? So referring back to the FOIP, as I mentioned in the beginning, so in ASEAN countries, including Japan, must aim to promote peace, stability, and prosperity across the region to make the Indo-Pacific more free and open as international public goods through ensuring rule-based international order, including the rule of law, freedom of navigation and overflight, peaceful settlement of disputes, and also promotion of free trade. So in today's presentation, as a law student, I focused on the parts written in red, so the rule of law and peaceful settlement of disputes. But here I do want to give you guys a question, not a question. I do want to ask, do you think that law would be the only solution to solving these issues? So in the South China Sea case, the unified and universal character of the United Nations Conventions of the Law of the Sea rendered it the most important legal instrument for the tackling of all matters and activities at the sea. However, this issue would certainly be considered question of the philosophy of the law concerning the relationship between law and also morality. So the concern breaks down into many issues, both conceptual and evaluative. But among the evaluative issues is the question of obedience to law. So does the fact that some norm is a legal norm provide any reason for countries to obey it? I would like you guys to think about this as well. So, in the absence of a codified definition of historic waters, jurisdiction relied upon customary international law and the opinion of jurists and judicial bodies. So, while the international law is certainly key to solving disputes, just as the South China Sea case that I introduced suggests, it is necessary to investigate the particular history of the matter in dispute, while also taking in consideration that historic titles must enjoy respect and be preserved as they have always been by long usage. So ensuring an international rule-based peace and order, including the rule of law, aiming to achieve peaceful solutions of all disputes is of critical importance. And at the same time, we must recognize that there is a limit to where law can take us. So as a law student and as I was researching this issue and presenting about this, I did think about this a lot, and I do believe that law cannot take us to law itself, just that itself would not be able to take us to a 100% resolution or in terms of international relations. So in terms of international relations, we must promote diversity as well as trust and humanity. And that would be the end of my presentation. Thank you.